A treaty is a formal, legally binding written agreement between actors in international law. It is usually entered into by sovereign states and international organizations, but can sometimes include individuals, business entities, and other legal persons. A treaty may also be known as an international agreement, protocol, covenant, convention, pact, or exchange of letters, among other terms. Regardless of terminology, only instruments that are legally binding upon the parties are considered treaties pursuant to and governed by international law. Treaties are roughly analogous to contracts, in that they establish the rights, duties, and binding obligations of the parties. They vary significantly in form, substance, and complexity, and may govern a wide variety of matters, such as territorial boundaries, trade and commerce, mutual defense, and more. Treaties establishing international institutions often serve as the constitution thereof, such as the Rome Statute of the International Criminal Court and the Charter of the United Nations. Treaties are among the earliest manifestations of international relations, with the earliest known example dating to the mid-13th century BC, and are today recognized as a primary source of international law. International law on treaties have mostly been codified by the Vienna Convention on the Law of Treaties, which sets forth the rules and procedures for creating, amending, and interpreting treaties, as well as for resolving disputes and alleged breaches. However, most treaties have internal procedures and mechanisms governing potential disagreements. A treaty is an official, express written agreement that states use to legally bind themselves. It is also the objective outcome of a ceremonial occasion that acknowledges the parties in their defined relationships. There is no prerequisite of academic accreditation or cross-professional contextual knowledge required to publish a treaty. However, since the late 19th century, most treaties have followed a fairly consistent format. A treaty typically begins with a preamble describing the high contracting parties and their shared objectives in executing the treaty, as well as summarizing any underlying events. Modern preambles are sometimes structured as a single very long sentence formatted into multiple paragraphs for readability, in which each of the paragraphs begins with a gerund. The high contracting parties, referred to as either the official title of the head of state and found them in good or proper form. However, under the Vienna Convention on the Law of Treaties, if the representative is the head of state, head of government or minister of foreign affairs, no special document is needed, as holding such high office is sufficient. The end of the preamble and the start of the actual agreement is often signaled by the words, have agreed as follows. After the preamble comes numbered articles, which contain the substance of the parties' actual agreement. Each article heading usually encompasses a paragraph. A long treaty may further group articles under chapter headings. Modern treaties, regardless of subject matter, usually contain articles governing where the final authentic copies of the treaty will be deposited, and how any subsequent disputes as to their interpretation will be peacefully resolved. The end of a treaty. The eschatology of its execution. The date is typically written in its most formal, non-numerical form. For example, the Charter of the United Nations reads, done at the city of San Francisco the 26th day of June, 1945. If applicable, a treaty will note that it is executed in multiple copies in different languages, with a stipulation that the versions in different languages are equally authentic. The signatures of the parties' representatives follow at the very end. When the text of a treaty is later reprinted, such as in a collection of treaties currently in effect, an editor will often append the dates on which the respective parties ratified the treaty and on which it came into effect for each party. Bilateral treaties are concluded between two states or entities. It is possible for a bilateral treaty to have more than two parties. For example, each of the bilateral treaties between Switzerland and the European Union. The treaty establishes rights and obligations between the Swiss and the EU and the member states. Severally, it does not establish any rights and obligations amongst the EU and its member states. A multilateral treaty is concluded among several countries. establishing rights and obligations between each party and every other party. Multilateral treaties may be regional or may involve states across the world. Treaties of mutual guarantee are international compacts, e.g., the Treaty of Locarno, which guarantees each signatory against attack from another. The United Nations has extensive power to convene states to enact large-scale multilateral